So to start our section, first, U.S. or most international employees can come to Canada as a business visitor without a work permit. A business visitor is someone that comes to Canada without entering the labor market. So for example, someone who comes to Canada for meetings, a site visit, training in product use, or a sales training. Business visitors must prove that their main source of income and their main place of business are outside of Canada. An important consideration in these cases when you're bringing a business visitor into Canada is to ensure that they have proper travel and medical insurance for their time in Canada. The real issues around compliance come into play when your employees are in Canada for more than a business visit. If they're actually going to enter the labor market, meaning that they're working in Canada. As soon as your U.S. employee enters the Canadian labor market, they come under the radar of the Canada Revenue Agency, health and safety regulators, and also become covered by the provincial employment standards and human rights laws. If the employee is in Canada longer than approximately 6 months and treats Canada as their residence and are considered a residence by Canada, which again DSF will explore further as we go through the webcast, they are taxed by Canada on their worldwide earnings for the year. If they can show they're a non-resident, they will only be taxed by Canada on income earned in Canada. And again, you'll have to remit the taxes to the Canada Revenue Agency.
Great, thanks, Catherine. If you send an employee to Canada and they enter the labor market, you will have to register with the Provincial Workers' Compensation Board, depending on which province the work is to be performed in. This means opening an account with the Provincial Workers' Compensation Board and registering your U.S. employees and also paying the premiums as required. Your U.S. workers' compensation insurance carrier may be able to offer an extension to your U.S. employees that provides workers' compensation coverage for their work in Canada, depending on the province. If that's the case, then you will still have to register with the Workers' Compensation Board in that province, but on the reconciliation form, check off that you are exempt from premiums because you have U.S. coverage and provide the extension coverage letter. Like any legislation, there are workers' compensation exemptions. For example, if the employee's position or industry falls in a category not covered by workers' compensation in that province. In Ontario, workers' compensation is handled by the Workplace Safety and Insurance Board, the WSIB. The Ontario non-resident policy states that employees in Canada for a period greater than 10 days performing work that is listed in the Employer Classification Manual means that the company must be registered with the WSIB for coverage for that employee. Workers' compensation in British Columbia is very similar to that. However, in provinces like Alberta and Quebec, employees are only covered if they are residents of the province. If you send your U.S. worker to Alberta or Quebec, you cannot get workers' compensation through the province. And should an accident happen, you are fully responsible for that worker through your insurance. So in this case, ensure your U.S. insurance carrier will cover the employee for out of country. Beyond taxes and workers' compensation, you also have to consider the compliance obligations with employment standards and human rights. An employee entering the labor market in Canada will fall under the Employment Standards Act in the province in which they are performing work. There are a few employment standards that you should be probably taking extra note of, even if your employees are only here on a short work project. Something like hours of work, for instance, will apply per province your employee is working in. We've had a lot of clients say that they want their employees working 60-hour weeks, but to do this in Ontario, for instance, it requires a written agreement and consent from the Director of Employment Standards. If you are requiring employees to work over the daily or weekly maximum hours of work, you have to pay them overtime for those hours, generally 1.5 times their hourly rate. You also have to account for public holidays, vacation pay, which is generally about 4% on gross earnings, and termination notice payments, which Marty from DFS will go into and expand on at the end of today's webinar. Of course, like with all legislation, you have to check for exemptions. So as we've seen, there are many things to consider when bringing an international employee to work in Canada. This slide highlights some useful options when the need arises to have workers in Canada. One option is to hire a Canadian to do the job where possible, and a third-party employer or outsourced employer, such as HR Options, can be the employer of record for you if you're not set up to employ in Canada. And this means the worker performs work for your company, and HR Options handles the payroll, tax remittances, and human resources administration in Canada. By using the employer of record to outsource your Canadian employment requirements, it does alleviate the pain points of having to navigate the Canadian employment system. Another option for cross-border employees to come and work in Canada is to go through the whole work permit process. Again, a third-party employer can help work with you on that in bringing the employee to Canada, and we always work with partnership with your company and the immigration law firm to ensure that it's a smooth employment to Canada.
So I'm going to speak about, by way of overview, 3 different areas that we need to be mindful of in dealing with cross-border workers. And in particular, they are, what are the differences between an employee and an independent contractor? What are the income tax obligations of the employer and the employee in each category? And is, in fact, the worker a resident or a non-resident of Canada? And what are the tax implications of each of those categories? So to start, an employer or an independent contractor, as a matter of law, really does require an analysis of the facts surrounding the relationship between the worker and the company. It really does come down to a question of fact as to how the employee and the employer or the worker are, in fact, conducting their operations and their relationship to each other. And generally, the courts have looked at, and the CRA does consider the following criteria in determining whether a worker is an employee or whether an independent contractor. And those 4 criteria are control, chance of profit or risk of loss, integration, tools and equipment, and I'll be going into a little bit more detail of those in the next slide. So the factors to consider, you can see I've just at a very high level indicated some of the factors that are being considered by the CRA in making a determination of whether someone is an employee or an independent contractor. And generally speaking, in reviewing these factors, you can see that the overriding principle is that the more control that an employer has over the worker, the more likely it is that the worker is going to be considered an employee. The fact that there might be a contract that says the person is being treated as an independent contractor, that in and of itself will not save a relationship from being considered an independent contractor relationship if there is in fact a risk of profit or loss or ownership or control being utilized, being retained by the worker as opposed to by the independent contractor. As opposed to the employer. So why is it important whether one is an employee or one is an independent contractor? It has repercussions on both the employee and the employer, the payer and the payee side. So if someone is considered an employee versus an independent contractor can have an impact on all of the different statutes that you see here. So all of these potentially are impacted based on the status of the person. And if the CRA does, in fact, conduct an audit and determine that a person is, in fact, an employee, then the company may be subject to significant taxes, penalties, and interest. So now residency. This is a question I get all the time because often when people are crossing the border to come into Canada to work, they don't think that they're potentially subject to Canadian tax because they're not in fact resident. But there are in fact 3 categories of residence, which I will go over quickly here. So the first is factual residency, and you can see that there's a long list of factors on this slide that are considered by the CRA in determining whether someone is resident, not relevant. So that's factual residency. The next is deemed residency. So that's a person who, and it seems like silly, but if you're determined not to be a factual resident, then you could still be considered to be a deemed resident. So that point is actually, in the first bullet point is put there on purpose because if you're not found to be a factual resident, and you have to not be found to be one in order to be considered to be a deemed resident. So it is important to make that determination. Now, a sojourner is a person who probably many of you will find some of your workers will fall into potentially. So a sojourner is a person who will cross the border and can be temporarily present in Canada for a total of 183 days or more. So this is important because a part of a day is considered a day for the purpose of counting the days to determine whether someone is a sojourner. If someone is a sojourner, they are in fact then considered a deemed resident for tax purposes. And then finally, a non-resident is a person who is not a sojourner or a resident, a factual resident. And I've indicated in this slide some of the ways where if residency cannot be determined, then there are tiebreaker rules in the treaty that can be utilized in order to make that determination of in which country the person is resident. And how do you minimize the risk? I mean, the most important way to minimize the risk is to get proper tax and legal advice prior to sending someone over the border, because the repercussions to both the employer and the employee for non-filing can be potentially significant, with extensive penalties and interest and potential director's liability for unremitted taxes.
What are some of the Canadian advantages from an immigration perspective? So first of all, relative to the U.S., Canadian work permits are more predictable and are processed faster. Some of the other immigration advantages under the Canadian system. So citizens of many countries are travel visa exempt and can apply for a work permit at a port of entry with no time delay. Basically, it's instant adjudication. If you don't need a visa to come to Canada, you can apply for your work permit at the border. Canada has no cap on the number of skilled foreign workers, unlike the United States, which does have caps on certain categories, the H-1B being the most famous or notorious one. Canada has a very generous spousal work permit program, granting spouses open work permits. These are spouses of individuals who are in Canada on other types of work permits. Since we talked about companies establishing operations in Canada, there is the very useful category known as the Intra company transferee, which allows foreign employees to be transferred from a related company outside of Canada to a parent or subsidiary or affiliate in Canada. Now, not all employees qualify. One must be either on a managerial level or an executive, or the worker must possess specialized knowledge, which is a defined term, far too complicated to get into here. Intercompany transferees can be processed on a very simplified and expedited process. Other immigration advantages under Canada's system is Canada's permanent resident program is generally predictable and relatively fast, with no per-country quotas as exist in the United States. Canada recently introduced a new express entry system, which is based on points, enabling relatively objective assessment of a candidate's eligibility. And most temporary workers can transition to permanent resident status and eventually Canadian citizenship, which ultimately leads to taking advantage of the various free trade agreements that Canada has with other countries.
Many of the American listeners are probably used to having at-will employment, essentially meaning that the employer can one day decide that they don't need an employee anymore and can terminate that employee. In Canada, we don't permit at-will employment. So what we're looking at is if an employee is terminated without cause or without a valid legal reason, then that employee is entitled to a severance package. If the employee is terminated for just cause, meaning that there was a valid legal reason for the termination, then they would not be entitled to a severance package. So just to give a couple of examples here, so when we're talking about just cause, again, so that's the valid legal reason for ending an employment relationship. we'd be looking at conduct such as theft, insubordination, dishonesty, or engaging in bullying and harassment of coworkers. Okay, and then when we're dealing with a termination without cause, so again, that's without a valid legal reason, some examples of a reason why an employer may want to terminate an employee without cause may be something like restructuring, insufficient work, not getting along with coworkers, and so on. So even though those would all be considered good faith reasons for terminating an employee's employment, the employee would nevertheless be entitled to a severance package. Okay, so I'm just going to go to my next slide here. We've skipped a few here. Okay. So I just want to discuss briefly here how to determine a severance package. So again, when you have an employee who has been terminated without cause, they will be entitled to a severance package. And there are three places that we have to look to figure out what that severance package is. So the first place we look is employment standards legislation. So in Ontario, as we saw earlier in the presentation, the statute is called the Employment Standards Act 2000. There are other similar statutes in the different Canadian provinces and territories. So the employee cannot receive less than their minimum entitlements under employment standards legislation. The second place that we have to look is the employment contract, and specifically what we're looking for in the employment contract is an enforceable termination clause. So it could be a clause that simply says that the employee is only entitled to their minimum employment standards entitlements, or it could be a clause which says that the employee, if they're terminated without cause, is entitled to 2 weeks per year of service or 3 weeks per year of service, and so on. Okay? And then the other place that we would have to look is called the common law, which is basically court decisions. And the common law notice period, if we get there, is going to be significantly longer than the minimum standards set out in employment standards legislation. And to be clear, when we're talking about a common law notice period, not only are we talking about, say, 3 months, for example, of notice, but we're also looking at things like benefit continuation, bonuses, shares, stock options, and so on. Okay, so in particular for the American listeners here who are used to having at-will employment in the United States, the best that we can do for you in Canada is to at least limit an employee's entitlement to the minimum entitlements under employment standards legislation if there is a termination without cause. So if that's your intention, I would highly encourage you to speak to a lawyer, because the courts have been getting quite particular about the language that would need to be included in order for those clauses to be enforceable. Okay, so I just want to get into briefly here a little bit about what we're talking about when it comes to common law reasonable notice. So if there is no termination clause in the employment contract, the sorts of factors that the courts are going to look at in figuring out what the notice period is, it's things like the character of the employment, the length of service, the age of the employee, the availability of similar employment in the workplace. Okay, the courts have established what we call an unofficial cap of 24 months. So very rarely would an employee be entitled to a notice period of more than 24 months. But 24 months, 2 years, that's still a long time, right? So if that's something that your companies wish to avoid, we recommend having strong termination clauses which can protect you from that. Okay, and again, to keep in mind, an employee's common law reasonable notice period is going to be substantially more than their minimum entitlement under employment standards legislation.